Hello. Hey, Jamie.
Hi.
How we doing?
Good. Oops.
Yeah, and I know Jamie and I have been following the Vicene case, but we kind of got enough of all the financial crimes. They are continuing that trial today. I think that lady is toast because she talked too much during her interviews.
Mhm.
That's why, kids, what's the first rule of court club?
Never speak to the police.
Without a lawyer present.
Yeah.
Yeah, it's um, it's not looking good. She lied to the police about her being a benefactor of the will. She told the police that Lynn wanted to do the Vicene mixtures because it made her feel less pain, even though Vicene should put you in a lot of pain.
Mhm.
And yeah, she seems kind of retard, as they say in French. It means late, Jamie.
I know. I got you.
Hey, fat
Party.
and Iris.
Hi, Iris.
And Greedy, but no, where did it jump on me? Greedy Bloke is here as well. Hello, Greedy. And Wolfram, yeah, wipe those paws down and get ready next to the fire. This will be a rewatch from Friday in the Kouri Richins trial. If people haven't seen that, that's the children's book author who is charged with unaliving her husband by slipping him I believe it was a Moscow mule with
Mhm.
a little bit of fentanyl in it.
Just a little.
Yeah. Hey, Wheelhammer and Miss Farrell. Good morning, Farrell.
Hey, girl.
Hope you got some sleep after work. But there were a couple of, I believe it's a couple of months ago, there was the famous walk the dog letter, as you can see. Now I'm pointing on my screen, you can't see that. On top of the screen, walk the dog letter. It's a letter that might be witness tampering, or it might just be her preparing a 65 pages novel she's writing in prison. She
Mhm.
has had different explanations, and she kind of screwed her lawyers because they argued, well, it's protected lawyer client privileges, and then she said something stupid. So yeah, again, never talk. Just let your lawyers talk.
I know.
Um, but still, today it's or Friday. It was a hearing to dismiss the charges against Miss Richins, and I thought we could watch that because, as I said, we didn't want to do the Vicene trial, and it's edited down to around 50 minutes. And we will be talking a little bit about what Jamie and I might be doing tomorrow,
Okay.
because as we got bored up, fell out of love with the Vicene case, we found that there's another kind of like Mr. Floyd case. If anyone remembers him, I'm not sure that's one of the names we can mention on YouTube, but this officer was off duty and put a guy in a chokehold, and he later died. I believe 5 or 6 days later. We will read up on that before we end this stream today, so stick around. That's a teaser. That's something you should do on YouTube to keep your audience here. You were off last. Well, well,
Yeah.
Farrell. Then you have no excuses for not being here.
Sunday and Monday, I think.
Well, I like a little vitamin C. See you next Tuesday if you get my drift.
You know how long it took before I realized what that phrase meant?
That I want to see someone next Tuesday.
Yeah. I
I don't know.
really was like, why is that like, why are people saying that all the time? And I was like, oh, I gotcha. I literally
Hmm.
thought people wanted to, like, see you next Tuesday. I was like, bye, Felicia. I don't know.
Oh, we can't all be.
I know.
I'm very street, as you know.
Yeah,
I'm hip with the kids.
I heard about it. I heard about you. So
Yeah, I'm down with the homies, as they say.
yeah,
Running with my crew.
I'm learning a lot of things on these YouTubes with you guys.
Yeah, we're not a good influence.
No,
You're too young and too innocent to be hanging out with us.
well, if you
But I blame Farrell. Farrell is the bad influence.
guys, you're rude.
Well, a lot of people say you're a bad influence, Farrell. No, we love you, Farrell. Without you, how would we know all the bad things?
No. How would I have learned so much in these last couple months?
Yeah. Just wait till Jamie figures out what an MFer is.
Well, I use that one very often, so I know what that is.
Oh, okay. Yeah, well. They have been waiting to go live, Jamie. Let them...
Well, I'm dog sitting, and so they're all jazzed up about their little cousin hanging out. Oh my God. Hang on.
Well, with Mac Parkinson and co getting angry in the background, let's go into... oh, this is her defense attorney. She comes off as a right B word, but in a good way, like a boss B word. She seems really sharp, and she looks like $1 million too. So I like her, and she will do most of the arguing today because she's a lead defense attorney, and I think she's one of those ladies who cost you a lot of money to have them represent you. Don't think about stuff like that. That I wasn't talking about that. But she seems very capable, and I like her. She kind of has like a praying mantis look to her. Hey, Christine, welcome. So, but if anyone watched this on Friday, please no spoilers because we didn't watch it. So let's just see what had happened was.
To address questions, or if you want to stop me midpoint and ask questions, however the board wants to proceed with that.
Perhaps I can begin with a threshold question, if you don't mind.
Yeah.
In order to grant the motion, I have to make a finding that some kind of conduct by the state's counsel rose to the level of a denial of due process or the denial of a right to a fair trial, right?
Correct.
A lot of that conduct you cite in your motion has to do with letters and filings made after a search of Ms. Richins' cell. And
I can see we just got a few more people in here. They want to have the charges against her dismissed because they, according to the defense, made an illegal search of her cell where they found this walk the dog letter, which might be witness tampering, or it might just be her researching and making notes for a novel. In that walk the dog letter, there was what could be suggestions that her brother should be remembering certain stuff if he was asked by the police. So that's why they wanted to the entire case to be thrown out. We get in a little off the mark, but we will be able to follow along. Just sit tight, and she will get us there. But she kind of looks like a praying mantis, doesn't she?
Yeah.
Yeah. I like praying mantises.
statements or allegations
Manti.
or witness tampering or the danger thereof. Well, what if they just amended the information and brought charges for witness tampering
Hey,
based
Wendy.
upon the same searches?
We'll
and the
try to
same
entertain you while you're driving.
Evidence. And I use evidence loosely. I'm not suggesting that anything's admissible or wouldn't be subject to a motion to suppress. We'd be right where we are right now, but I don't think that would be misconduct.
I don't think so either, and here's why. If they had formally charged her, she would be given due process rights as it relates to to the alleged witness tampering, right? We would be able to cross-examine people, she would get a trial, we'd be able to present witnesses, we'd have arguments whether or not evidence was going to be admissible or inadmissible. The problem with the way the state has characterized this in their briefing is the fact that they have definitively said she's guilty of it without being afforded any of those. And I think being charged with something is different than the state saying she witnessed tampered. This isn't the first time she witnessed tampered. This is further evidence of witness tampering, all of those things. And then they go on to say, you know, not only did she witness tamper, but because she witnessed tampered because she's guilty of murder. Like her witness tampering is a consciousness of guilt. And I can pull it out of the briefing. We prepared it in slides, but that's the problem, and that's the violations of rules 3.4, 3.6, and the UDA standards, is you can allege some through a filing or through a criminal complaint, right? She's here today because the state's alleged that she committed a number of crimes.
Sure.
Right, and she's gonna get a preliminary hearing, and we're gonna go through this entire process.
Bielhammer, it's kind of like when you watch Ricada, how can a person with so tiny shoulders have such a big nose? It's God plays with nature sometimes. And she has a very strange face. She's a very pretty lady, but she looks scary. I don't know what it is, but there's something very exotic about her. I always, when I see her, think about if you read, you probably never, it's not big in the US, Asterix and Obelix, about these two guys who fought against the Romans. And there's one where they're helping out Cleopatra, I have to say it in English. And they always say, oh, that nose. And I think Wendy has it right. She had done some trimming to that nose. I think she might have been having I got kind of a snouse on me as well. So it just looks weird, but she's a pretty woman. I don't know what it is, but she's just pretty. She's one of those ladies, when you look at her, you think, why is she pretty? But she is pretty. Yeah, the Busby type. Well, we don't demean her or anything. I think she's a very attractive woman. And she has, one of the things that makes her pretty is the way she carries herself. Even in the highest of heels, she has a very good posture. Cleopatra. We put the emphasis in the beginning of the word. You put it in the end. So we, instead of saying Cleopatra, we say Cleopatra.
What? I love it.
Yeah, you learn so much.
I do.
Hey, Jess. Good morning. Good morning. You're up early as well. Yeah, let's get back to this beauty.
Before we get to say she's guilty or not guilty. And the problem with the state's characterization over and over and over again, and in fact it got progressively worse or progressively more definitive in their statements that she is guilty of witness tampering, and that's the narrative that the media has picked up. And I think that's the violation of the rule, not, if they had charged her with it, you're right, we would still have to deal with it. And perhaps there would be some press surrounding it. But we would also then have the opportunity to refute that or go through due process rights. But by just saying she was guilty of it, and by saying she was guilty of it is bad. By saying she witnessed tampered as a consciousness of her guilt is worse. By saying she administered the fatal dose of fentanyl is worse.
So
And they're
pause there
tying all
for a
of
minute.
this together.
A lot of that water went under the bridge as of the detention hearing. That is their theory of the case, that there was a financial motive, there was poisoning caused.
I don't like that pin behind the ear.
No,
For spouse. I mean, that's the case.
you haven't had.
Then we have requests for
Where's Luna?
things
She
like
normally
don't
lost
let
for this
her
guy.
talk to certain individuals because, and then once we get into the because, their justification for the request is, we're concerned that she's trying to alter their testimony at a future trial. Stated broadly, everything I just described is part and parcel of lots of criminal cases.
Right, except for the fact that they go further to say, they have a theory, right? It's in the probable cause statement, it came out in testimony of the detention hearing, you're right. That happens in every single criminal case, and we can cross-examine people and weigh the credibility of witnesses as we go through, okay? The problem is in their
Hey, Shani.
briefing,
Hey, Jenny.
they dispel or they characterize the defendant's alternative theory or
Good morning, Alan.
perhaps a potential theory of the defense as a false narrative, that it's a lie, okay?
Sure.
Which completely diminishes the credibility of anything we say. And then they've gone on to say, and all of her witnesses are lying, and she's telling her witnesses to lie. So now we're in a position where anybody we put up there, a jury pool is gonna say, well, I mean, she witnessed tampered, so obviously these people are lying. And the state's already said that anything she says is a
Hey,
false
Lexi.
narrative because it doesn't fit their theory.
Good morning,
That's a
Rosman.
problem, and the rules specifically prohibit the state from commenting on the theory of the case, or on alternative theories of the case, or on the credibility of witnesses. And
Trying to determine where the line between permissible advocacy and impermissible communications that would
well,
irreparably damage the jury pool. I acknowledge that however long jury selection was going to be at the end of the detention hearing, it seems like it's 3 times longer now. I'm with you. I got it. But why can't we?
Ladies, on every channel, it's always the ladies we talk about smash or pass. I know we have done this a couple of times. This judge, Luna sadly isn't here right now because I know her take on this judge.
Mhm.
I think her quote is, I would use his face as a seat. I don't know what that means. It's probably something you say in the US. But I think he looks like a listener. He's a guy you could talk to.
Yeah. I don't know.
Yeah, maybe just for the chat interactions, let's do a poll because it's always with the ladies, people are asking smash or pass. But let's see how.
I'd say pass. I'll pass. We got a pass from Iris, a smash from Stray. Oh, Stray, you're hilarious.
Well, it's okay to lust. Well, and the gavel and say, you've been a bad girl. I hold you in contempt. And then hammer you with his little gavel. Or maybe his big gavel. The road can hide a lot of stuff. Yeah, but maybe if he calls her a bad girl. Because it's only me who can chicken out on the asexual one.
No, Iris. Baker
No,
just
this
wants
is the,
chat interaction.
this case is about the children's book author who might have helped her book along by getting rid of her husband and then writing a children's book about how her two sons missed their dad. This is just a hearing because they wanted the case dismissed because they claim by doing certain public statements she won't be able to get a fair trial. They have broken the gag order on the case, and that's why they are having this hearing to dismiss the case. Yeah, who watches the watches? That's always a great question. That's Latin, Jamie, but you knew that.
Of course. I know everything.
Well, Wolfram, we can't see who votes in the polls, so yeah, we never know.
Yeah, no one will ever know. Just press a button.
But Alan, if you don't know what it's about, as you can see in the header, the Walk the Dog letter, that's from, they did a search of her cell in the prison and found a letter that might have alluded to witness tampering. And that's what the state is, the state have been out publicly saying, oh, she's trying to tamper with the witnesses in this case, they can't be trusted. And that's why the defense is saying, well, she can't have a fair trial because you had prejudiced the jurors against her by saying that everyone is a liar and have been coached. Funny enough, when the state coaches help people remember their testimony, it's not a problem. Well, he has a lot of hair. He just keeps it short.
Yeah.
It's not like he has the Michigan hairdo where everyone is bald on top.
It's a Michigan hairdo.
Yeah, what case was it where every officer had the I don't know the white side middle parting? Hey, Sauter.
Maybe he has lice.
Did I think of something?
No, it was just Iris, what she just commented.
Yeah.
Oh my God.
Well, I'm not saying there's anything wrong being bald. I cut off all my hair when I was deployed, but he has the hair to grow it out. It's not like he's well, like me, he has a 5 head instead of a 4 head, but he could totally rock longer hair. Oh, she took the H off the Irish, but she's still my little Irish Rose.
Mine too.
No, Fed, I'm not pulling that one up. Well, allegedly, we have to see the evidence, but it didn't look good that she tried to get the money paid out to her when it was supposed to go into a trust for his kids. And yeah, she seems like a piece of work. Yeah, the judge in the Meyer trial, I think he had like the Homer Simpson haircut.
The 2 strands of hair.
Yeah. Jess have no hostages today. She going full ball with those.
Boy. Hey, get it, girl.
Iris, she's been waiting to get something off her chest today. I can feel it. Yeah, my little Irish Rose. Hey, Linus, so we're just watching a hearing from Friday in the Kouri Richins case, the lady who might have helped her husband off the planet to write a children's book about it. They
And
want to have the
guy, everybody, remember?
oh yeah, he's the guy with the no sleep policy when he had a bowel problem.
Yeah. Always having emergencies on the way to family functions. So he'd show up with no socks and no sleeves because he apparently crapped his brains out and he had to use his sleeves. I can't believe that that's something that somebody said in open recorded court about
Yeah,
this.
it's
That
in
was his legacy, guys. His legacy.
it's in the record.
It's in the record.
Just you can come on and be my co-pilot when we're doing it if you're into it. Yeah, that two strand, it just looks foolish.
Mhm.
But
Through a combination of lengthy and careful jury selection and instructions to whatever jury gets selected, mitigate the harms that you're describing.
I'm just gonna go blow my nose again.
Okay.
I'm gonna answer this in two ways.
Sure.
Okay, the first one is, I wanna address first is the rules are clear about what they can and can't do. And the rules are clear about prosecutors in particular, what they can and can't do. And they have a heightened duty. And there's case law out there that specifically says they have this heightened duty because things that come from the government come with more indicia of credibility, right? If the government's saying she's a liar, and the witnesses are liars, and any theory she has of the case is a false narrative because it doesn't fit theirs, that's a violation of the rules, like period, I think. Or at least that's our position, is they have clearly violated the rules in doing that. And in going so far as to make statements about her guilt. There's been a violation of the rules. I think what you're getting to is potential remedy, and I think the prejudicial effect is that this is everywhere. We pulled, I mean.
But it was everywhere long before
It
this.
was, but it was everywhere before the state started making these comments. It was going to be everywhere. I don't think, I mean, I'm not gonna sit here and say that all of, this wouldn't have happened, or there wouldn't have been news stories, sure. There would have been news stories about this case no matter what we did, and I think that's a given. The problem is now these news stories have adopted the state's interpretation of the letter. And the news stories have run with.
Accurate? I mean, I have assiduously tried to avoid news coverage of the case,
Right.
just to make sure that my consideration of it wasn't polluted by any inaccuracies in the popular media. But even I bumped into the cover of People magazine, which seems to indicate, or have at one time been providing a counter narrative that seems to be provided by the defense side of the case. I mean,
I think there
why
is a
isn't this a case of both sides airing their competing narratives to the fullest extent they believe is permissible under the rules?
I think you can advocate, but I think it has to be within the rules. And when you go so far as to essentially say she's guilty of witness tampering, and because she witness tampered, she committed murder, and the Today Show pulls a snippet and puts it by her face that says she, told these people to lie about whatever it is, that's a problem. And I think
Those are some
that
high
goes
heels.
a step too far. Yes, we can all effectively
She's
advocate.
told
We're gonna do it
to begin with.
throughout this case, I'm sure. But I think there's a line in what you can say, and I think the rules are very clear on it. And when the state.
I knew Luna would be snooping around when this judge was around here. Yeah.
Hey, Luna. Morning.
It's a good way to start your Monday morning with a little of Judge Hanson.
Mhm.
State starts making conclusory statements about her guilt, about the credibility of her witnesses, about her credibility, about my credibility. I don't think, and then the narrative becomes, and the comments that we've pulled are, she's guilty, she's, why are we even doing this? This is just a box to be checked. Like, these are local comments. And yeah, you're probably gonna get some of those, but
Yeah,
the state has taken it.
Anybody know that? Like, did they let her put on makeup before court, like while she's waiting? She made herself a
Yeah.
eye there.
Yeah, and they let her have her street clothes on as well. So, and I think with this judge, she has a spare, I would say chemistry set, but that's not what it's called. A makeup set in her bag that she can use. She knows how to present her in the best way possible in court. And she is looking way better now than she did in the last hearing we were covering. That she was very pale in that one.
Yeah, I was just curious because, like, I didn't know they gave you that sort of stuff.
Well, it's the same thing like giving you a tie or something, but they probably are allowed to bring her real close because we've seen in other cases. Do you remember the young girl Dave covered with the lie on the dad, who were forced to wear the same clothes for 5 days in court? That was a bad thing.
Well, I definitely know they give you clothes. I just didn't know they gave you makeup, let you have makeup too. So,
well, I'm not sure they give you makeup, but I'm pretty sure her lawyer gives her makeup.
hey, she might.
Yeah, because she knows how to present. You can tell, even though someone feels like she needs a stairmaster.
And the other thing I want to address is there was an alternative method to this. And in the APA comments, this goes to the second part of your question, 2 questions ago, regarding, if they think she witness tampered, can they bring a motion and ask the court for relief? The answer is yes. Okay, I think we can agree on that. The problem is in the way they characterized it and the statements they make in their brief. The second problem is it should have been, our position is it should have been done differently. And the APA comments speak directly to it, and it's 8-2.
I can't remember. I'm thinking.
Point.
She did an interview with Dave. She seemed.
I'm gonna get there. I can only remember so many numbers. Point 1. And what it says is a lawyer participating in a criminal matter should not place statements or evidence into the court record or into a document that is deemed an open record under applicable law solely for the purpose of circumventing the standard. If the lawyer has reason to believe that the public release of the record or document would create a substantial probability of harm to the fairness of a trial or other overriding interest, the lawyer should consider seeking a sealing order pursuant to standard.
Megan
Pause there.
Imorovich. What's her name?
In order for a violation of the rules to be material, it has to have caused irreparable prejudice such that due process is violated, she can't get a fair trial. So let's stay focused there. I'm just not sure we're at that point, given the amount of publicity that existed beforehand, what the comments probably said before all of this, the availability of other measures. Dismissal is the ultimate sanction. And correct me if I'm wrong, I don't think you cited a case in which the case was dismissed prior to trial for this kind of conduct rather than during trial. Am I right about that?
Or after.
Okay.
Correct. Candidly, I did not find a case that stated that. I think
Can we just acknowledge
Yeah.
that during trial, the options are so limited. The jury's already in the
Right.
box. We
Right.
can't re-impanel.
Right.
Jeopardy's attached.
Right. I think that is a different scenario. I think some of the cases though that came back on appeal, right? Like it didn't get dismissed during trial. The conduct occurred prior to trial. And those cases came back on appeal, for a new trial.
I don't
Those
like
are
how she says,
kickback, side deal, right, not
It
pre-trial.
sounds like a high schooler trying to defend a
Correct.
paper.
So I do think it's nuanced, it's difficult in cases. I think we can all acknowledge that. But there is a process in place to ensure we can do the best we can, to take care that we all do the best we can, not to violate any of her rights to a fair trial. And the state, in their assertions and the statements they have made, have not done that. And the prejudice is we can't undo that, okay? This letter is out there forever, right? Whether it's ultimately admissible at trial, doesn't matter at this
It
point.
matters a little bit, doesn't it? Because if it were to come
I mean, I'm
to
gonna argue
trial.
it matters because I'll probably move to motion to suppress it, but
Well, sure,
Right.
so I mean, but, and I'm not expressing an opinion one way or the other
Right.
about any kind of motion or.
Puffer, she seems very competent, but when she slips up with that, and it's probably kind of like a tick. We have a Danish politician. We had a Danish politician who famously couldn't say a sentence without going, and I know it's kind of like a thinking break you need when you have to think on your feet, but it just doesn't seem very good when you go into, I think, or, it's, it kind of weakens her argument. Yeah, as Greedy says, she doesn't sound convinced by her own arguments. No, it's a Hail Mary. I know they have to try to do everything to get this case dismissed if they can, but still, she seems like she's not 100% behind it, and again, she's just going through the motions. Yeah, I think it's kind of like a mental catch up where you kind of go, oh, I need to think, and then you go like, oh, or I think. It's kind of like when you go to school and you have to defend a paper you didn't really study. Good morning, genitals. Welcome, genitals.
In that regard, but imagine the letter came in a trial. Any pretrial prejudice is now mooted. It's in. The actual jurors have seen it and heard it.
the problem is the statements the state has made during the pretrial phase, right? The statements that they have interpreted, this letter's open to multiple interpretations,
Sure.
right? And yes, we can get to that through cross-examination and
If it comes in.
at trial.
Right.
The problem is
Let's see.
that there is local, national, global media where
Lucky
the
you.
state has interpreted the letter in the way they want and has put out to the world and all of our potential jurors that Kouri's lying, that her witnesses are lying, that her theory is false, that that's the problem. The problem is their
Most
statements
important
and
part
the
of your
way they
day.
interpret
Say
it.
good morning to your
And the
genitals.
prejudice to her is, you can't undo that. I mean, sure, we can probably ask people, questions in voir dire, but
Now we talked about it. I can't unhear her saying, all the time.
Yeah.
It sounds like a Valley Girl, like, when they say like, when I went to the club last night, it was such a blast, like all the guys were nice, like I know it's a mind tick that she probably can't help, but it's annoying the hell out of me. It's not the greatest angle. She has, as Wilhammer said, she has a large nose that still looked like it's squashed in. She has kind of like a I think she had a bad nose job, and I can't really decide if she had her cheekbones fixed.
She doesn't have the greatest side profile, but yeah, she is pretty straight on, I think.
Yeah, but I have the problem that I'm prettiest with a bag over my head.
Whatever. Side profiles are, it's hard to come by. It's hard to look good on a side profile, I swear, for everyone.
Yeah, that's when you can see all the flappy skin and stuff like that.
Oh, we're terrible.
Air words. Okay, I didn't know it had a thing you called it.
What?
My bridesmaid didn't have as sharp features as her, but she looks like her. Well, you had a nice bridesmaid.
And if she had a nose job, she should get her money back because that's not very good. And I guarantee that's natural.
Jessica, you can wait till you see the judge. Luna alone would smash on his voice, but wait till you see him. I think he's a pretty man.
It's kind
I
of
don't
50.
think that's the thing.
Yeah, it's kind of 50-50, but we'll let it run. Luna will fight people who says he's not good.
Given the egregiousness of the statements. If it had just been, the way in my opinion, the way it should have been done, or the state's or the defense's assertion is they could have moved the court for a motion for no contact order. They could have filed it under seal. They could have filed the letter.
Well, Jessica, I can give you, if you don't know the case at all, I can give you the quick rundown. This is the case with the children's book author, Kouri Richins, who might have helped her husband off this planet, and later wrote a book where she got famous because it was a self-help book kind of for her kids to handle their grief of losing their father. She was very famous. She was on all the TV shows, Good Morning America and stuff like that. And then the police thought, well, he had a suspiciously large amount of fentanyl in his blood, and she might have slipped it to him in a Moscow Mule. They have a co-worker. We covered the first hearing in the trial. They have a co-worker who might have procured the fentanyl for him. And I have a very roomy sound in my studio today. I don't know why. She might have
like
been doing some
or something. Like that's what they said.
She was a house flipper.
No, the lady that supposedly got the fentanyl.
Yeah. She worked for her as a house, maybe some cleaning lady, some stuff like that. She had different jobs. Oh, doggo.
They're scared.
What's that big
thundering? So.
Oh.
She's a Saint Bernard Collie mix. She's a big baby.
Yeah, she's a big dog. Yeah, she's charged with helping her husband off the planet by way of fentanyl, which she might have gotten through a co-worker, and there were text messages about that. Never use your phone if you want to do stuff like that. It's a bad idea. We also had his sister tell us, and that's why we got hooked on this case, tell us that every time they had a family function, they were afraid that he would show up without sleeves or socks because he might have had a toilet accident and used it for, yeah. So that's why we got into this trial, because Jamie just loves it when people talk about missing sleeves.
That was so crazy. And first of all, I feel like you need to make that a clip so that you can play it every time we're watching something with this, so people know what we're talking about. Because that was the craziest thing I've ever heard. Somebody say in open court about their loved one.
Yeah.
I would come and haunt my sister until the day she died if she told some crazy story about me like that.
Well, this was a Moscow Mule, if I remember right. So, but a lot of people have been unalived after doing adult beverages. Jamie, how's your eyeballs today?
They are effed up because I should have never. That was really stupid of me. But I'm here. I got eye drops in. I'm trying to make it through.
I'm missing some part of the.
I cleaned a room, and I did it in a really fun way. And the dust got all in my eyes, and now I'm just like, it's burning a little bit.
Yeah, that doesn't sound like a great. Just don't drink the eye drops.
I didn't drink them, everybody. I put them in my actual eyes.
Yeah, it's always the phone. Don't use the phone. Well,
okay.
that's why we're here. That's to try and help people if they don't know about it. Yeah, but you probably watched it. It kind of blows up every time she goes into trial because there was this children book angle, and it's out of Utah, I believe. So
Yeah.
it's gonna be an insane hour of my day that they're gonna. That's California time or something.
Yeah, PST, yeah, Pacific time zone.
Yeah, I'm gonna have PSD when watching this trial.
You need to go lay down, baby. It's just thunder. It's fine.
Yeah, we were covering that eye drop killer, but we kind of dropped out of it because that was so much boring financial evidence. And I know today they picked up with her kind of admitting to doing the crime in interviews, but they're set to go for 17 days more, and it didn't move along. So we kind of said, well, we're going to drop that. We will be talking about another trial in the end of this stream that we might pick up tomorrow if they have a jury seated. Oh. Exactly. It was my psychic abilities. Hey, Carissa. Yeah, she admitted to mixing the Vicine drinks for the deceased because it helped with her pain. Right. Oh, Wilhelm and Eris is streaming the eye drops trial in Dave's Discord. Yeah, if you become a member at MLS's channel, you can go in there and follow that. Well, you go take care of your phone call. Well, now I know when I meet Eris, I have to make thunder noises.
They're under seal. You know, we could have had this argument or in a way that wasn't the state saying that she witnessed tampered. It wasn't the state saying that her witnesses lied. It wasn't the state saying she's guilty of murder. Those are the problems. And those aren't going to go away. Forever, there's going to be this issue that the state's
just hey, Julia, Jude,
and they can't do
Jude. Hey, Jude.
And if the courts, and I granted dismissal is the ultimate remedy, right? But there are alternatives. I don't think any voir dire is going to cure this issue, given the egregiousness of the statement.
So I looked at your, or I shouldn't be, defense's proposed alternative remedies. I'm not prejudging a motion to change venue, but you haven't provided a basis to change venue yet. The dynamics that we're talking about, as far as I can tell, exist statewide, nationwide. This case was covered by the BBC. I don't know that you will find a jurisdiction that is certainly not the state of Utah that is going to be materially different than Summit County in terms of its saturation with media coverage of this case.
Correct. I think there will be other grounds, and that motion will come. We're
Okay,
fairly early in
all right.
the process of this. So I do anticipate moving for a change of venue, based on, I agree, unless we're going to some tribal land and gone,
Yeah.
we're probably not finding people
Well,
where it hasn't
as I say,
touched, but
I have no
I think
challenge.
there are other
I have
issues
fun.
that we will bring to the court's attention, that we believe would support a change of venue. We don't need to get into that
Agreed.
today, but I do anticipate that will be coming.
Then we have disqualification in the Summit County Attorney's Office, and I'm not sure why that follows. Here, at this point, aren't they the most sensitized to the issues and the permissible bounds of what they can and can't say, rather than somebody else? Well, they've been involved, they're going to be subject to whatever ruling they make. I don't understand why disqualification of that office based upon public comments, conduct they've taken in prosecuting case making motions, rather than extrajudicial things like those things that exist in other cases that were discussed in the briefing of embezzlement, bribes, that kind of conduct. Here, if you're right that they violated some ethical rules, well, now they know, and I would remain confident they wouldn't do it again.
I don't think that cures the problem.
Tell me why, though, on a going forward basis.
I-
What is it about the continued involvement of the Summit County Attorney's Office on a going forward basis that would be prejudicial to this region?
I think if the court takes no action against the Summit County Attorney's Office, they're sanctioning what they said. And I think that adds additional credence to their statements.
Am I the only one who's feeling like she's on a massive fishing
And I think that's a
expedition,
problem.
trying to
Further,
just
they've
get
been
something to work for her client?
involved in the
It's
in the
Utah.
investigation. Allow me a little more, thank you. So, when they began investigating this,
This lady is the lead defense attorney for Kouri Richins, the children's book author who might have helped her husband get off this planet and written a book after to help her two sons handle their grief. This is a hearing where they are trying to get the case dismissed because there was a search of her cell where some pieces of paper known as you can see in the opening, in the headline, the walk the dog letter, where they said she implied that witnesses should lie in this case. And now the defense is saying they have prejudiced the jury pool against her by implying that she lied and by implying that every witness will be lying. And that's why it should be dismissed. But normally, this lady lawyer is very, very sure of herself, but I feel more and more like she's in a, she's going to need a bigger boat. She's out to catch the mother of all fishes right now. It feels like a fishing expedition. Well, I know she's protecting her client, but we have seen her with a lot more confidence in the other hearings. And if it's unethical, I don't know. He finds that it's not. Well, so far, but let's hear what the ruling will be in the end of it.
case, I was having communication with the Summit County Attorney's Office. So they've been involved since the very beginning of this investigation and throughout it. And so they are intimately intertwined in the entire investigation as it went forward. Further, then they've said that this is our theory, there's no other theory, and the defense theory's got to be a lie because it doesn't fit with our narrative of facts, right? The problem is, you know, there's an insinuation that perhaps they drove the investigation, and this is where it ended up. And if it's,
She's a very pretty lady.
well, they made the ultimate conclusion that she's guilty in their briefing.
Okay.
Okay. And they were involved with the sheriff's office throughout the entire investigation. And they're saying that, you know, any alternative theory, say we, you know, go out and investigate and have investigators working and come forth with additional things or alternative theories or whatever, they've already said that can't be true because it's a lie.
Okay.
And because they drove the investigation or they were so involved in the investigation, I don't, you know, maybe they didn't go look for any. I think the implications
That's
of,
a great closing argument regarding Ms. Richins getting railroaded, but I'm not sure that justifies by itself
I think
disqualifying the Suffolk County Attorney's Office.
I think in order to fix the narrative that the state has put out there, there needs to be drastic measures. And one of those could be, or should be, you messed up and you're off the case.
I understand that argument.
I mean, I think that is the only.
That's why I'm saying she's on a fishing
the
expedition
only
right now.
way to correct.
But again, it shows the
the
defendant that
violations that
they are
we've
working
alleged.
for her.
Is to say, you know, that they made mistakes, they violated the rules, and therefore they're not on the case. I think that
Well, there might have been a financial
puts us back a little
incentive
bit
to
to
do it.
center, where now we can go forward and we can present theories and there's a message out there that says, look, they shouldn't have made those statements, they can't make those statements, and by disqualifying them, the office as a whole, I think it sends a message to potential jurors that that's incorrect. And that there's
Isn't that
potential.
problematic as well, though? Or we'd be sending a message, I mean, we'd have to exclude all the jurors that had any sense of that, that were going to draw any conclusions upon that. We need potential jurors that were agnostic about that.
Yeah, and she moved around. Her kids were beneficiaries on it, and
Meaning
there was a
they
lot
didn't
of,
have an opinion one way or the
shenanigans.
other
I
regarding
have
the motives
the
or
first
conduct of
hearing
any
in
of
the playlist for this.
Right, but there's still, I don't think without proper remedies from the court, it restores Kouri's right to a fair trial.
Okay.
I mean, at the end of the day, we can't, doing nothing, essentially just adds credence to what they said, and she's in a place now where, you know, we can't call these witnesses, I mean, we're gonna call witnesses, but, you know, we're on the presupposed motion or assumption that, you know, the world has taken that they're liars, because that's what the state said. And they can't make those, you couldn't make those in a closing argument. They couldn't get up there and say those things for a reason, right? So you should be able to say it now.
Well, let's be more specific about that. If they wanted to get up and say that, for example, if Ms. Richins testified to X, Y, and Z, I think the state would be able to properly say, listen, compare X, Y, and Z to evidence A, B, and C. The inconsistency
Yeah, they
shows that
do
X,
kind
Y,
of
and
look
Z
the
is a
same.
false narrative. That is proper closing argument.
Right, but it'd be based on evidence,
Fair enough.
right?
Yeah.
And you could, that is, I mean, that's what you advocate in closing arguments. You can say, you know, we presented this, the jury gets to weigh the credibility of everybody's witnesses, including the defendant, and make their own determination. They've circumvented that entire process by saying it now. They predispositioned everybody to look at these people through.
Carissa, how long have you been following trials on YouTube? People do really, really dumb stuff because they think they're smart enough to get away with it. But again, we don't know if she done it. We're gonna wait till all the evidence are presented and the jury reaches a verdict. As we always do, we really put an emphasis on the good old tested innocent until proven guilty. Not like some people on other channels think that you are guilty until proven innocent. But I'll just say that the narrative told about this, it seems kind of like there were some arguments about she was a house flipper, and she might have gone in a little bit too heavy on some financial deals that the husband was angry about. That's the state's alleged reason why the stuff happened. She had a very contentious relationship with her family-in-law. I don't know if that's the right way to say it. His family. So there's a lot of stories out there, but how much we can trust, it's always hard, because right now it's just storytelling from both sides of the aisle, and the media will pick the headline that bleeds the most, because that drags enough people to watch it. I should really spruce up my headlines as well, because I've seen other channels really go deep on the bloody headlines.
Mm-hmm.
Yeah, I don't think as I said, and he mentioned that in the beginning, the cases she gave him to prove that it had been done before was in appeals or during a trial. It wasn't pre-trial. So again, it seems very much like a fishing expedition where she's trying to just throw a Hail Mary. And as a Giants fan, I know you can throw a lot of Hail Marys, but that won't take you to the Super Bowl. And that's, but again, you have to work for your client, and she's doing that. She's working for her paycheck today.
Mm-hmm.
But let's see where it's going. Carissa, that's why I have a channel. It's because I like to explain things the way I understand them, and I love to hear all of your ideas, because I can get smarter. Actually, I'm a Giants fan because everyone else was a 49ers fan back when I started getting into football. And I like the Knicks, and I like the Mets. I like the teams that never win.
Then why don't you like the Lions?
Because I watched the Beverly Hills Cup. And they were already a bad team back. No, it's because my brother did a year abroad in, I think he was in Jersey. So he brought back a Giants cap. And since then, I've been a Giants fan.
Oh, okay.
I watched Tandick yesterday.
Did you?
Yeah. They didn't show the Giants game, but they showed the Dallas game. I watched some of it, and then I tried to go to bed, and then I ended up talking to someone till 3 o'clock in the morning. So I'm not that smart. Well, I'm not trying to reverse anyone's attitude or open anyone's mind. I just like to have a discussion, because, as I've said many a time, I've been in politics for 20 years. I hate people who are so set in their minds they can't change. And I used to be one of them. Is Danish folklore full of giants? No, we don't really have giants, but we have a lot of Viking myth about, we call them Jætter, and they're kind of like trolls or giants. But there's a lot of that. We don't really have, the only real Danish folklore we have about a giant is a Swedish giant lady who was so mad at a church ringing their bells that she threw a rock after it, and it landed just north of where I'm living, and that's the largest rock in Denmark. But that was a Swedish, again, Swedes, good for nothing. But that's the largest rock in Denmark, and it's just north of where I'm living. And that's kind of like the only troll we have. But if we go back to the old Viking folklore, there's a lot of trolls there. So Nick and I should do a Viking show about the folklore, because no, Thor wasn't from Australia and had long blonde hair.
I wish he was.
He was a chubby redhead.
Yeah, that's what you said.
Yeah, that's what he was.
The lens that they're lying, to look at Kouri through a lens that she's
I'm gonna blow my
lying.
nose again.
To
Sorry.
look at Kouri through a lens that She is trying to get people to lie for her, to look at counsel, frankly, through a lens that I'm doing improper, I'm doing nefarious or criminal acts is what they've alleged. So that's the problem. They have essentially hit every single part of the rule that you're not supposed to violate. And the comment to 3.6 lays out things that are materially prejudicial. So I think that answers that question where they're making these statements now. 3.6 in the comments specifically says these things are materially prejudicial. And those are the things that they've done here.
I understand your position. It won't be the last time you get to talk. Let me hear from the state. Was there anything else you wanted to put on the record in the first place?
No.
Okay. Mr. Pleasant.
Good afternoon, Your Honor.
State's briefing was a little general in terms of we haven't done anything wrong, there's no prejudice, let's just move on. Address Ms. Lazaro's argument that the things that the state said in its briefing related to the walk the dog letter are not the types of things that the state would be allowed to say in closing argument.
Your Honor, they are the things the state would be allowed to say in closing argument. It is fair argument, fair advocacy based on facts in the record today. And that's an important point here is
This
that
guy.
He
This
looks like he
guy-
wants to be an extra in a mafia movie.
Oh my God, the hair gel budget with this guy.
Yeah. Maybe he's on the Gorilla Glue treatment.
Maybe. But he loves that hair gel. That is his style. Look at him. It's so slicked back, like perfectly.
Yeah, he looks like he could be an extra in what's the one who always do the mafia movies?
Godfather?
No, the Fedorowski will hate me for not knowing that. Who's the director I'm thinking about? The one who always uses Martin Scorsese. Yeah.
Good Lord.
Yeah, Beowulf was an old Nordic fairy tale as well. So there's a lot of. I should make some readings of Nordic myth. As any good Viking, I have the sagas or the stories about the gods and the heroes from the old Viking myths. But it's in Danish, so I'll have to translate it.
God.
Yeah, I like the 13 Warrior. It's not no, Beowulf was. I know it happened in Britain, but it was a Viking story. With Grendel and Beowulf.
with first
Is it raining?
It's hailing.
Oh, it's hailing. Yeah, I thought, were you clicking your keyboard, but then I thought you looked around.
No, because I was just like, it's hitting the window so hard. I'm like, what the hell is that? And it's little balls of hail.
Yeah, it's a fun time of the year. You get all kinds of weather right now. We just got rain, and it's Minosaur is getting angry. But you went to school and studied something, I believe, that might make you know more about this than me. I'm just a baker. I don't know anything.
What do you mean, Indigo? Why am I this? I'm working, so I have to be awake.
Well, we can fix that. I can read it in Danish, and then you can try to decipher it. That's amazing.
Good Lord. It's gotten louder. That's crazy. All right, whatever.
It's nice to get a cup of cocoa and a book, and then have the hill outside.
I know, I kind of do want to go back to bed. I should tell my boss I'm sick.
Amendment, jurisprudence on public access, consistent with the court's rulings on public access. These are public debates. These are the debates where the state makes its case in a filing, and the defense has an opportunity to rebut that case in the filing. They just rebutted it, not only in their prior filings, but right here, right now at this podium. And that is fair litigation. That is how cases are litigated in criminal courts throughout Utah every single day.
Would you acknowledge that during jury selection, we will need to identify jurors that have knowledge of a whole long list of things, including the briefing, media coverage regarding the walk the dog letter and the manila envelope, and any number of other things?
Yes, Your Honor. Undoubtedly, the court and the parties will select a fair and impartial jury. That will take longer than normal. That will take a jury pool larger than normal, an enlarged questionnaire, expansive.
Luna does.
But there are people in Summit County who are not voting in this case, at least a dozen or so. And there are people.
45% of people do.
That's not a lot. Vinasaur, I believe you. It is a Anglo-Saxon, but it's from between 500 and 1,000. So yeah, we didn't go over there and visit until 786, I believe. So it's probably just me wanting it to be a Viking thing. Yes, an old English poem. Yeah, Vinasaur, I defer to your superior knowledge of Beowulf. I'm a baker. I'm not that smart.
Who we can see is very impartial. Summit County Court set a jury that won the Poucher matter that received tremendous publicity. The court was right to note that much of this publicity is both national and international. More so probably than Summit County. I can think of 2 pending cases before this court, one civil, another criminal, that are receiving as much local ink as this case. And the court will see Summit County juries in those cases as well. As it relates to the walk the dog letter, and kind of this instant discussion we're having.
Why can't he use the microphone as well as she could?
Because he's too short.
Insights in his briefings. In dicta makes, I think, a pertinent note that
Just do this.
the
I know. No.
publicity at issue in the prosecutorial misconduct and retrial motion was kind of a drop in the bucket to the overall publicity that the case received over the arc of time. That's where we are here as well.
Okay. Anything else from the state on this motion? We have plenty of other ground to cover.
Your Honor, if your questions are answered, I will sit down.
All right, thank you.
Thank you, sir.
Ms. Lozar.
There are a couple things I'd like to address. The if you
Please.
would so indulge me. The first point I'd like to bring up, and we addressed it in our briefing, is the state in their response briefing to this doesn't address really prejudice, as the court just noted. They don't address it at all. That they're, I mean, essentially, what they say is it maybe doesn't matter, that this is out there and so be it. The next thing, I think it's important to look at the statements. The state is saying that they could say these things in trial. They could say these things, perhaps some of them, if they're supported by evidence in closing argument. What they can't say, and I think I'll just pull out a few of the ones that I think are particularly problematic, is, they first say that the court needs a no contact order to prevent the defendant from further engaging in witness tampering. Essentially implying that she's witness tampered before.
Right, but I come back to.
Well, we did that the
hypothetical
last time I did the case. I mean, it's always about the ladies.
I know, but isn't that better for her?
Well, yeah,
I have a
don't want him more
78%
targeted, I agree
female
with you.
audience.
But isn't it a proper exercise of
I think
prosecutorial
that's
discretion to say,
way out.
that is a distraction to prove that lesser charge? We're gonna focus on the top level charges that are in the information.
I'm gonna put off the
Absolutely.
booster. It's
and I
text, so
don't-
you can read along, because that background noise
So
is
the
so
only reason I
annoying.
raise that is to say, in that alternative universe that I am describing my hypothetical,
Mhm.
the information, the preliminary hearing, all that stuff would be transmitting the message, she's a witness tamperer. That is not different than we have here. It might be worse.
It might be, but it might not be, and here's why. The state concedes in their brief that they didn't have evidence that she ever passed the letter or witness tampered, right?
Right.
So we would actually get to stand up here and say or cross-examine people to essentially prove that that wasn't true.
Well, that's probably
So,
not to
and
lean
I don't
too
want
far in
to,
one
yeah, I mean,
direction,
I don't
but
think that
why I'm
matters.
disinclined to prevent her from talking to her mother and her brother.
But the issue is that they have just declared that she's guilty of it, right? Instead of.
Is there anybody in the world that thinks the state of Utah doesn't believe she's guilty of the crimes for which she's been charged?
Is there anybody in the state of Utah? Well, I hope so.
Well, I guess, no, not that they believe personally, but that does anybody out there think the state is just doing this as theater? I mean, the state's position from the beginning is she's guilty.
Right.
I don't think they've been unclear about that.
No, but the problem is that they've used, the way they've drawn the inference between witness tampering and the ultimate decision that the jury is gonna make in this case after it hears evidence is that because she witness tampered, is a consciousness of guilt. She induced people to lie because she's guilty, right?
Isn't that similar to some of the arguments that we heard on which I relied during the detention hearing regarding the internet searches? Consciousness of guilt, trying to hide conduct. I guess what I'm saying is that why is making arguments regarding a particular piece of evidence, admissible or otherwise, showing consciousness of guilt, why isn't that a proper conduct rather than improper conduct?
Well,
Whether it's media
that's not what they
attention
said. They
Because
said
the
that,
rules
do anyone
specifically
think
say
that the
they
state,
can't
the
comment on
DA's
guilt.
office,
The rules
don't
specifically
believe she's
say you
guilty?
can't comment
The way
on
he
the
worded
credibility of her witnesses.
The way he
The rules
worded.
specifically, I mean,
Yeah.
it's clear in the rules.
Hey,
It's
Danny,
very clear in the rules what you can't do, and that's what they've
it's
done.
But
the
you're not
Florida of the
suggesting that
West.
the rules prohibit, as a matter of law, making.
Thank you so much,
arguments
Sandra.
regarding consciousness of guilt in a pretrial finding.
I think when you tie it to the ultimate, I think it depends on the context, right? I think you could use this phrase, consciousness of guilt, in a number of different ways that doesn't say she's guilty of witness tampering, we're telling you she's guilty of witness tampering, and because she's guilty of witness tampering, she's doing it because she's guilty of murder. And that's what you can't say. You can't go that far. Yes, there are probably a number of ways you could argue that in different ways that may not violate the rules. But the way they've done it here violates the rules because they're specifically commenting on her guilt in this case. The other thing I'd like to address is the ABA standards essentially say there's different ways to do it. Like you could have done it under seal. This wouldn't have been an issue. She spent a vast amount of money. Taxpayers have probably spent a vast amount of money and time on this issue where we're not working, we're limiting our ability to work on other things. We're doing this. Ultimately, this rests on, or what's alleged, she violated jail procedure policy. As well, if they make that determination, okay? The jail has internal remedies to deal with that. And the jail has decided that she recently violated one of those, and they have prohibited her from contacting her mother. So there were other ways to accomplish this goal without creating a media narrative with the state's position on her guilt and the credibility of her witnesses. And I think I just want to turn the court to the Hensley case. We relied on it in our briefing.
Is that the Fifth Circuit case?
It's a Fifth Circuit case.
That was during trial though, right?
It was.
Okay.
And I get that sometimes it's different. It can be different during trial because you didn't panel the jury. Those are the people who are sitting in it, right? I think that is different.
By implication, no other available alternatives to mitigate potential prejudice.
Correct. But it's still, and maybe these don't get litigated. I don't know. I mean, I don't know the answer to that. Maybe, I don't know how many arguments are had. If this were a case without a lot of press, okay? If this were normal course, like my 60 other whatever cases I have, right, that are going through the courts, sure, we litigate things on the record.
We're doing fine.
Right? It's not getting broadcast out to potential jurors. And so when you look at those types of cases in a normal course, it may not be problematic. I mean, it may still be a violation, but the prejudice may not be as grave as it is in this case. Because, nobody would see it, right? The jurors, I panel juries all the time that have never heard of my clients and have no clue about anything that happened, and they go about the normal course of business. And so the only thing that's brought to their attention are the things that are said in trial. And so that's why I think most of the
she doesn't seem that strong in her arguments.
I
have to say,
this case is different.
I liked her better in the first hearing.
Has so much publicity. Greater care should be taken to ensure we're not tainting a jury pool, to ensure we're not saying the things in pretrial matters that we couldn't say at trial, because the effect is the same. We're potentially causing the same harm that would happen in those other cases to a jury when it's broadcast to the world, where we have, jurors that have likely heard of it. And I don't think that the extent that the state has gone to in this case can be remedied short of I mean, obviously, we're here asking for a dismissal, but alternatively, without grave sanctions against the state. And we suggest that they be removed and to start over or continue forward, that's what I should say, with a clean slate, in order to, put some order back in and, go back and ensure her fairness, her right to a fair trial. These premises aren't lip service. I mean, this is essentially the most important thing we can be arguing at this point, is whether or not
The
we
audio
can
turned real
ensure
bad.
that she gets a fair trial. I think
That's-
that ultimately
this-
is
why
the
we
most
have the
important
CC on.
thing in a criminal case. It's, the lofty reason a lot of us started doing this in the beginning, because we we're gonna be a champion for the rules. But, and I don't mean to make light of that, I think that's true, for most of us who do this. But it is the most important thing, and so it can't be just, well, as the state says, like, too bad it's out there, we're just gonna keep going, it's fine. It's not fine. It's not fine because they violated the rules, and the result of that is worldwide prejudice and a world that thinks that her liars and her witnesses and her counsel, are gonna misrepresent things to them or lie to them. And that's a hard thing to remedy.
I think your position.
Thank you.
Thank you. The issue before the court is defendant's motion to dismiss due to prosecutorial misconduct. Gravamen of defendant's
I'm not that
motion
smart. You have to
is that
say what you mean.
due to conduct by the Summit County Attorney's Office, defendant has been denied due process and her right to a fair trial. Specifically, defendant asserts that statements made by the Summit County Attorney's Office in briefing related to the walk the dog letter, briefing related to the Summit County Attorney's Office request for further limitations on Ms. Richins' ability to speak with her family members, have included statements.
Thank you so much for the
that
gifted
violate
membership, Luna. And it went to
3.4
TG.
And 3.8.
TG must be a lurker. I haven't seen that person in chat.
And
They are more than
Utah
welcome to becoming a member. And thank you so much.
Those statements include things like, quote, defendant is engaging in witness tampering or needs to be prevented from further engaging in witness tampering. The motion for no contact was based on the defendant's witness tampering and breach of jail security procedures. The walk the dog letter illustrates the defendant's consciousness of guilt with respect to certain explanations made by the defense for certain actions, that no such link exists in the evidence, that defendant concocts a false narrative, that defendant's own handwriting, she attempts to induce her brother to testify falsely, that she is facilitating witness tampering and supporting a false factual narrative, that she is giving her mother instructions to induce her brother to testify falsely, that this may indeed not be the first time the defendant witnessed tampering, and that defendant is making a frantic, dishonest attempt to explain how fentanyl came to be involved in this case. When viewed in isolation, these comments raise concern that they would cause undue prejudice by tainting.
The defense is arguing that because they had a hearing about the walk the dog letter, where they claimed that she was witness tampering and making instructing her brother how to answer questions, that she wouldn't be able to get a fair trial. And they kind of circumvented a gag order because they haven't charged her with witness tampering. So they shouldn't be allowed to claim that she did witness tampering. That's the motion that this defense lawyer have been arguing today. But as we heard them say, or the judge say, they have also been out and saying stuff in the media. So it's a two-way street. But now he's going to give us his ruling if he finds their argument are sound.
The view of potential jurors in Summit County, the state of Utah, nationally, internationally, regarding Ms. Richins, her credibility, the credibility of her counsel, and her ability to defend herself in a fair jury trial. But when read in context, and given how these comments are anchored to evidence in the record and motions made by the parties, these comments are within the bounds of professional conduct under Rules 3.4 and 3.8. These are examples of permissible advocacy on behalf of the state in support of its request for things like further limitations on Ms. Richins' ability to discuss, contact, correspond with certain family members, and also in response to arguments made by defense counsel related to other litigation topics. Moreover, before this issue arose relatively recently, this case had already received an inordinate amount of media attention, an amount so large that it is frankly not in the interest of justice. But the First Amendment works the way it works, and I can't prevent that. What the court can do and require counsel for the defense and the state to engage in is measures to mitigate any potential harm from publicity regarding the advocacy in this case on a going forward basis. And that would include careful, lengthy, and detailed voir dire jury selection. We will need to identify jurors that do not have any preconceived notions about the subject matter of this case or any of the people involved in it. Parties, counsel, witnesses, etc. That may be a lengthy task, but it was made lengthy long before this issue arose, given the pre-existing publicity regarding this case. Moreover, these arguments would have been appropriate and without objection, the court expects, had Ms. Richins actually been charged with witness tampering. In that situation, the court would be making determinations about whether or not there was probable cause for the charge and there was probable cause to bind her over for trial. And these very same arguments regarding potential consciousness of guilt and materiality of the letter would have been made and would have been wholly appropriate. Here, based upon the briefing currently before it, the court simply isn't persuaded that the conduct of the Summit County Attorney's Office violates Rules 3.4 or 3.8, or has caused Ms. Richins a denial of due process or a denial of a right to a fair trial. The court is confident that it can preside over a sufficient voir dire process to ensure that Ms. Richins does in fact receive a fair trial. For these reasons, the defendant's motion to dismiss due to prosecutorial misconduct is denied.
Well, That was a short ending. She was denied. After watching her defense attorney, I'm not that surprised because she didn't seem like she really believed the stuff she was selling. So yeah, but still, it's going to be a very interesting case, I believe. Again, there's a financial motive. There's animosity between the families. There's all this talk about, did she keep the kids from his family? Did the family try to get her out of her own house? So it's going to be an interesting case to follow when it goes up.
Oh yeah.
Well, let's just say I have seen worse attorneys, and again, she is throwing everything at the wall and hopes some of it would stick. But yeah, again, I like that attorney. She had a bad day in court today. We can see why she didn't have a good thing. So
Yeah. I don't think
to
she had
argue, but
her argument, like, it wasn't gonna fly anyway.
hey, Holly. Yeah, we're having an awesome Monday because we're just about to finish. I don't have to sit here all day today. I still can't get over my cold. But talking about sitting here all day, we might, if the jury have been seated, be looking at this case tomorrow. It's the former Milwaukee police officer, Michael, and I don't know, Mattioli?
Matoli? That's what I'd say.
Mattioli? I don't know. I want to make it Italian and say Mattioli, but it's the Midwest, so it's probably Mattioli.
Matoli.
Mattioli, you know, the guy down from he knows where all the muskies are. I don't know what a muskie is. It's a fish or something.
Yeah, it's a fish.
Yeah.
Muskrats too.
But we might, if they seated the jury and are ready to go for tomorrow, we will be covering this case. It should run about a week, maybe 2 weeks. So we can get in and out of that because that Vicene trial was just bogging me down, probably because I was sick as well. But if you don't know about this case, it's a homicide trial. Happened back in 2020 when this police officer was off duty. Joel Acevedo was at his house. They had a party. He put him in a chokehold and neck hold. It's kind of weird because, as you can see here, stop that. Well, prosecutor said that the 25-year-old Jose Acevedo was at a party at Mattioli's home in April of 2020. Mattioli told police he woke up the next morning and found Acevedo going through his pants pockets. Mattioli put Acevedo in a chokehold for several minutes after an argument. He died 6 days later in the hospital. He was charged with first-degree reckless homicide, and he has resigned for the police department. There was a lot of commotion about him resigning because they couldn't fire him. And there have been a lot of changes in the staff at the DA's office, and I believe at the forensic office. Someone just stopped out of the blue, and it has been a trial with a lot of hiccups in it. And it happened around the same time as something I can't say, I believe, on YouTube without losing my monetization for this stream. And again, it's, as I said, it had taken a long time because of the disease I can't talk about on YouTube and the untimely retirement of key witnesses, the former medical examiner. And what will be the key evidence in the case? And in this case, it's not going to be like a self-defense type of defense. It's going to be about the cause of death. The prosecution is saying it's asphyxiation because of the chokehold. The defense will say it's a combination of some type of medical issues combined with the use of drug and alcohol, like we have heard in another case. So it'll be an interesting case, I think. There's some unedited body cam for Jamie, that word.
Footage.
Footage. What the officers saw when they arrived at the scene, and it took him quite some time to get him off of him. But again, he said, well, he didn't choke him; he just hold him. So it's going to be interesting, and I hope they got the jury seated today so we can go for tomorrow.
Yeah.
Yeah, it's a dish with a lot of Parmesan. Well, I've been having a cold for two weeks now, and I just can't get over it. I'm so tired all the time. So, well, Holly, you're bringing Jamie and I into the shower with you. Oh,
Yay.
thank you. Yeah, just like in the Henderson case where they were Snapchatting in the shower. Nasty kids.
Why- Just take a shower and then Snapchat. Jeez, oh Pete's.
Yeah. But Jamie, yeah, we aren't surprised after watching this hearing that they didn't get the case thrown out. Let's just say that.
No.
I like her. I like the lawyer, but she had a bad thing today to do. That's yeah.
I mean,
Yeah, Holly, please don't drop your phone.
I can see like how this is tough because I mean, that got blasted all over media. So it
Yeah.
looks, it's not making her look like it's not making her look good at all.
Yeah, no, and it's not making it look good at all. But again, they are also using the press to get their side of the story out. So it's very easy to be holier than thou, but they have to try and use every trick in the book to get her off. And I respect them for it because we've seen we saw the opening statement in the Florida case, the Troner's case, where they kind of just stood up and said, yeah, we're going to preserve our opening statements. And that's all they did. And they didn't put on a defense. Just said, well, he's not guilty. You can see it in the evidence. And yeah, we kind of could see a way to get him out of it. But still, I've seen worse performance by a defense.
Oh yeah. And she's got money, so she paid for her defense.
Magnesium citrate. Well, I do take magnesium and zinc and all that stuff because I'm an old guy. We need it for our testosterone levels.
Zinc
What
is
did I say this time?
for sure. You need zinc,
did-
not zinc.
Yeah, but I take that anyway because as an older man, you need it to keep up your testosterone levels and get your sleep. Yeah, and I might because at the veterans union where I attend the bar sometimes, we have had a few cases of the coof, so I might be having a bit of that, but I'll try to go to the gym tomorrow if I can get in bed at a proper time tonight. If the young ladies don't call me up all night, dang Americans, then I will be ready to go tomorrow. I hope. I've been drinking lots of fluids. I've been taking my vitamins, and I just have to get over the hump, and then I'll be good. I'll be fine. It's
Yeah.
I just whine. The most annoying thing is that my nose is running the whole time, and I just get so tired. So yeah, and everyone I know has it as well, and I might not have been really smart going on your day on Friday and been up a bit too late and drinking a bit too much, but it was fun. You put some good in with the bad, but no. So the plan is tomorrow, if and when they have this this jury seated, we will pick it up and follow that case, the Parmesan guy case. Because I think it's kind of interesting. It's another one of those. Did the chokehold or the drugs kill him? There have been some social issues. Again, I have to word my words carefully on YouTube surrounding this case because of the ancestry of the victim, but it hasn't blown up as much as in other cases. So it'll be interesting to see what evidence in it. It's citrate. The regular ones are usually oxide, and those are not good for energy and sleep. They go straight through your system since they are just a mild X. Oh, well, I buy it at my gym. No, not the good stuff, but so it should be to get into my body. Scooby snacks. Well, I always thought, and maybe it's because I don't understand English, Scooby snacks is a euphemism, right? For a little of the devil letters.
Is it? You got me.
What do you say, people?
I thought
As,
snacks were like dog treats.
I'm not on antibiotics. My gym bro asked me, "Have you gone to the doctor?" I said, "I'm a man. If I haven't had a fever in 3 days, there's no reason to go to the doctor." Well, I have to. Can you buy that in normal stores, or do you have to get a doctor to get it for you? I'll have to look into that. Cheesecake works great. Well, I'm gonna be having a cold forever.
He'd rather die than eat a piece of cheesecake, everybody.
No, it's called ZMA. It's zinc, magnesium, and B6. I think it should help us older guys boost our testosterone levels. So yeah. Bill was streaming Vicine in Discord. Not sure if he's going to pick it back up or not, but he might. Yeah, well.
Oh, I didn't know that.
Yeah, and it's never good to drink when you're dehydrated because it dehydrates you more. So, well, why should I go to the doctor? Will tell me you got a cold. Go home, lay down on your couch, put on some TV, and get warm.
Seriously,
Yeah,
every
I
time
know it's a
the doctor with a cold, they do that too. They say the same thing. They're like, it's viral. You just need fluids and rest.
Yeah, you can't do anything about it.
That was bad.
And it's a cartoon, yeah, but still, isn't it? I just think this because Scooby and Snacky are kind of like kind of like Snoop Dogg and Willie Nelson. Let's put it that way. It's yeah, and they would again. I think it's maybe not a dog treat. I had the day off on Friday. And Saturday I only was on with MG for a short while. Yes, Mom. No, I'm gonna end the stream. I'm gonna make me some dinner, and then I'm gonna go in and lay on my couch for a couple of hours and take my comforter on me and just relax. And then I'm gonna try and go to the gym tomorrow and hit the sauna to sweat it out. He is a Great Dane, Scooby. I know that.
Well, because I bought my dog's treats, and they're called Scooby Snacks. So I didn't know if that was.
Yeah, but yeah. Well, ladies, some ladies like to call
No.
men daddy.
Don't.
So
And if
that's
you do,
just
that's cool, but that creeps me
no,
out.
it's not. That's so weird.
That is so
I
weird.
hate it. I like girls with daddy issues, but I don't like being called a daddy. Maybe it's
No.
because I have daughters. But again, we got sidetracked.
No.
So yeah, it's there's a lot of things we could do and should do and stuff like that. But I need to go and lie down, get some rest, and be ready for tomorrow because hopefully we will start the other case.
Valhalla, you have something to do. You have some goats to feed.
Thank you so much, Valhalla. Yeah, but I still think that it's a euphemism for something else. Something that yeah. It's I still think the Scooby Snacks really are so. And with those words of me breaking down Scooby-Doo and ruining Jamie's childhood, I should probably go about my day. And everyone, go out there, have fun. If they got the jury seated, I will go live sometime tomorrow when I figure out when they're gonna do it. Other than that, go out and yeah, it's supposedly, but I wouldn't know that because it's illegal in Denmark. We never do that. Yeah, let's call it. It's the flavor from Amsterdam. It's the ingredients of Amsterdam. Yeah. I don't. I just yeah. It's I just think that that Scooby and they didn't like the Scooby snacks just because it was snacks. But everyone, go out there. Don't touch the devil's letters. Come back tomorrow, all rested up and ready for another trial if they have the jury seated. Jamie, thank you again so much for joining me. Lovely as always. Chat. Goodbye. Oh, it's working again.
It worked! Yay!
Give me a thumbs up. Let's go out with a bang.
Nope.
No, 2. Bye.